Hello and warm welcome to yet another edition of the Final Take with me, Seni Marina. In the studio today, we have a special guest, Mr. Sergio Barro, a prominent Gambian legal scholar based here in the US. We're going to talk about the Gambia's legal system. Sergio has written extensively about the Gambia's legal system, constitutionalism, rule of law, and accountability. So we will be talking about the legal system in the Gambia. So enjoy this show. We will bring after the short break, we will bring in our guests.
Tune into the final take with MK Mariner every Saturday on the Alcamba Times and experience extensive conversations on a variety of topics, including national and international headlines, breaking issues, and major developments in politics, business, innovation, science, and sports, along with inspiring stories and expert analysis to provide a comprehensive understanding of the news.
Welcome back, wherever you are tuning in. This is the final take with me, Sini Marena. Welcome back. Sergio, welcome to the final take with me, Sini Marena. We had a little technical issue initially, so we couldn't come as planned on time. But here we are. Sergio, welcome to the final take.
Thank you. Morning, good afternoon to your viewers wherever they are tuning in. And then it's a pleasure to join you here, Mr. Marina. I know you have published extensively some of the writings that are engaging, but I'm grateful for the opportunity. But most importantly, happy July 4th to all of us here. And
Yeah.
then where liberty dwells, that's where our home lies.
Yeah. Happy July 4th to everyone watching this show. America is at 250 years of freedom and liberty. And then we thank God, for that freedom that everyone is enjoying. So happy independence to Gambians in the US and elsewhere. Mr. Barrow, I know today is a very busy day because it's World Cup, and World Cup, everybody wanna watch. Africa has only a few remaining teams. That's Morocco and Egypt, and Morocco is playing Canada in few minutes, so we might miss the first half, but hopefully we'll be done before the second half. Sergio, thank you for your time and sparing all what you're doing to come and join us on this show. So, Sergio, you are a Gambian legal scholar based here in the US. Can you briefly tell our audience, those hearing about your journey from the Gambia to becoming a prominent voice on Gambia's legal and constitutional matter?
Thank you for that opportunity. I know when you use the phrase Gambian legal scholar, I'm not sure how you mean, but if that denote that I'm a Gambian born and raised before immigrating to this country, that is correct. Am I an attorney by profession? Yes. And then do I write extensively regarding Gambian matters? Again, true. But as a disclaimer, I am not licensed to practice in the Gambia. I'm not a member of the Gambian legal fraternity, and then I am licensed and then practice in the United States when I was in private practice. But I just wanted to make that here. But as you rightly mentioned, I was born and raised in the Gambia, precisely from, we all hail from Nyamina,
Yeah.
and then close knit over there. That's where my journey started before finally I was in Pakalende in Jara, and then where I completed my educational system before I immigrated to this country over 2 decades ago. And
Wow.
then where I did my undergrad and then finally trained as a lawyer.
Absolutely. Congratulations, Sergio, for that career journey from the Gambia to the highest pinnacle of law here in the US. You must be motivated, about your scholarly writing. You're very busy, but you have been writing extensively about Gambia, from legal affairs to rule of law to accountability, legal system, judiciary, political governance, especially afar from America here. Tell us, what inspired you to write extensively about Gambia, even though you are not living in the Gambia right now, but you have a very special interest on Gambia?
Um, I guess the short answer would be that's my way of giving back. Gambia has given me foundation, has given me discipline, and then focus to get to where I am right now. And then whether it's a cause or blessing in law school, the one of the pains and then penalties of joining law journal law review require you to write a lot. And then I did a lot of writing over there. And then while in private practice, I have not written on Gambia extensively, but as part of my practice and then the area I am more focused on, I write extensively in that area from 2015, 16, 17, whether it will be in Wisconsin or for my law firm. We have a blog where I have to write about constitutional issues or immigration issues or pressing matters in the area I practice. It just comes with the territory of being an attorney in the US. And then you have to write about those hot topics. And then now that I'm somehow brittle, and then I can write about Gambia, which would create less conflict. That's my way of also giving back to the younger generation and then at least inspiring them to motivate them the culture of reading and writing.
Absolutely. That is something that is lacking in the Gambian educational system, both higher education to inculcate the spirit of reading, among Gambians. Most Gambians will react without reading. When I see your scholarly writing, I will be like, Sergio, you write so well. I hope people are reading what you are writing, because your objective is to send the message across, especially to those in the legal field, being law students, law lecturers, judges, even officers of the court. So good job with that. For many viewers, Mr. Barrow, the Gambia's legal system is still somehow mysterious, and then you can spot those mysterious things from some of your legal writing. Can you give us a clear overview of its hybrid nature, common law, customary law, and also because Gambia is also practicing what we call Islamic law, and how they interact in practice today?
That's a loaded question, but at its core, we are a constitutional republic, and I want people to understand that. Is our legal philosophy or jurisprudence grounded in common law? True. Before we became a constitutional republic, Gambia was colonized by England, and then England's heavily shaped how our jurisprudence is. So we all drive common law from good old England, just like the United States and others. But in 97, we became a constitutional republic. So the Constitution is the floor and it's the ceiling. But the Constitution allows us to have those duality, because it recognized the uniqueness of Gambia because of our culture, religion, and all whatnot. But when it comes to civil, well, not civil law, because that also means something, but let's say when it comes to legal practice, our tradition is common law, judge-made laws, state decisis, all that stuff. And then, but it also recognized that Gambia, a majority Muslim, it also carved out exceptions when it comes to personal matters, areas in marriage, inheritance, and divorce. It allows us to follow our Islamic jurisprudence in that area. Both, if you are talking about our court system, the one most people interact with outside of personal area, that is heavily grounded on common law in terms of how we develop our jurisprudence. Common law basically means judge-made laws, people made of stuff, custom tradition, that's what it is. At its simplest terms, is just judge-made law, but the flaw is the Constitution. And then that tells us that in as much as we are incorporating common law, we now have, as a self-governed country, this is where we draw the line. And then common law must fit within that ambit.
So Gambia is a common law country by legal, but also we have Sharia law. We have Sharia appointed judges who normally look into issues of inheritance, marriage. How do you walk through these two types of a system, a common law and also a customary law in a legal system of ours?
Well, it's a delicate balance, both because the Constitution is the primary legislation or the canon we have that address how we live as a society. The Constitution itself allowed derogation when it comes to certain rights, in as much as the Constitution stated that everyone is equal under the law. It expressively carved out that any discrimination that this Constitution recognizes is okay. And then that discrimination goes to, for instance, for Muslim, Article 7 of the Constitution indicates that when it comes to personal law in the area of marriage, inheritance, and divorce, the Constitution would allow these individuals to subject themselves to their Islamic faith, not every area. So by default, if you're someone of a Muslim faith, if you get married through the Qadi system or our Islamic system, you automatically are subjected to that Islamic jurisprudence when it comes to marriage, inheritance, and then divorce, as the religion dictates. But you can opt out. That's the beauty about it. And then we have seen people who will opt out, or knowingly or unknowingly. If you go to the Attorney General's chambers where you engage in civil marriage, that act of doing that is affirmatively opting out of that Islamic jurisprudence, and then you want your marriage to be registered under civil jurisprudence. So it's a balance, but they all have a limit, with the Constitution being the flaw.
Sergio, why I asked this question is that, I cover the courts extensively as a reporter while I was in the Gambia. And now as an editor of Alcamba, I have reporters who I assign to cover the courts extensively. And then you have been following a lot of court reportings that inform most of your legal write-up, because I see you quote so and so newspapers in your legal write-up, which is amazing, which is great. So I see a judgment recently that went through a Sharia court, but a high court judge set aside that Sharia judgment. Is that illegal? How can you explain that part of, do the normal common law have oversight over customary law in Gambia's legal system? I want this to be clear, because a lot of people see judgments like that and they're a bit confused.
I'm not sure the judgment you are referring to, and then that's important in order to know, where the limits are. But let me, as a general rule, when it comes to Sharia jurisprudence, right? And then my understanding is, and I hope that's how it is, we have Qadi court. And then if we're dealing with Sharia, it's the Qadi court. I'm not a theologist. I don't know Islamic jurisprudence. But the people that are well-grounded in Islamic jurisprudence will address, anything that has to, that involves marriage, divorce, or inheritance. So if you have the Qadi court, that will be the equivalent of the trial courts of the Gambia Islamic jurisprudence. Whatever judgment the Qadi court announce, if someone is dissatisfied with that judgment, they have a right to appeal it to the Court of Appeals. But even at the Court of Appeal, it has to be the Qadi appellate courts. The Court of Appeal might be sitting, but the judges there would have to be grounded in Sharia Islamic jurisprudence. And then they are going to review to see whether that lower court actually applied the Sharia as required or interpreted. So if you see a Court of Appeal overruling a lower court, Qadi court jurisprudence, it's important for people to know, in as much as the misnomer, we call it Court of Appeal, it is dealing with the Sharia Qadi Court of Appeal that should address whether that decision dictate the Sharia law, or whether the issue in fact falls squarely within Sharia jurisprudence. And then that could all the way go to Supreme Court, and Supreme Court could also address that issue. But it has to be on, if it is found that this matter that we are dealing with squarely falls under Sharia jurisprudence, the ruling must dictate under Sharia law, however Sharia law announced that. And then you have a right to appeal that all the way to Supreme Court, and then but the judgment or the jurisprudence have to be grounded in Sharia. Now, our Constitution also gives us the ability to follow customary law, because the Constitution, it lists a series of laws that it recognizes under Gambia, including English common law, right? It also includes customary laws. And then these might be relevant in the area of land issues or other traditions. But there is a caveat that the Gambia Supreme Court set aside. We will allow people to perform their custom in terms of, let's say, how they bequeath land or how they inherit land, but it has a limit as long as that custom or practice is not repugnant to the purview of the Constitution. So if, let's say, this might be, well, I don't want to use that, that might be a little bit controversial, but let's say, you know, how, well, that's the beauty about law. When it comes to FGM area, that's a customary practice. Now, some people might say it's religious, right? Let's say, but let's assume for the sake of argument, we all agree universally this is a customary practice. And then people are handling it. And then your argument is the Constitution allowing me to practice my custom. And then if that case were to be appealed and someone wanted to protect that individual you want to subject to FGM, the law will look at the custom and see whether that they find that custom to be repugnant to our way of living or our decency laws or moral laws in the society right now, and then to see whether that custom we should discard that or not. So that's how it will interact if it involves custom, but if it involves religion, then Sharia Islamic jurisprudence should take precedent over that.
Amazing. Thank you for that clarity, because if my memory recall, I have seen a judgment that was put aside by a high court judge, and the judgment was delivered by a Sharia court. So that's why I bring up this question. But thank you so much for that brilliant answer. Sadio, you have also written extensively about Gambia's judiciary. What are the key arguments in your scholarly work regarding judicial independence or the lack thereof under both the Jammeh and post-Jammeh era?
I'm of the opinion during the Second Republic, we cannot argue that the judiciary is an independent or co-equal branch of the government. That's my position. And then I believe TRRC findings and then the testimonies at TRRC revealed that. However, under this current administration, judiciary is very much independent. My argument is not about independent. I think the judiciary is independent. The government gave them the latitude to be a third co-equal branch of the government. My argument goes to the funding. Judiciary, there's a structural problem over there, but first it has to do with finances, and then to maybe reform and some changes to help access to justice to be available to the ordinary citizen in Yemen. That's where my writing, when it comes to the institution of the judiciary, my argument is as a co-equal branch, they need the money and the funding in order to reflect the 21st century judiciary system we ought to see. And then two, the judiciary too must recognize, in as much as the gains they have received from 2017 to now, that they too require introspection and then change some of these laws or rules that are making it difficult for people to have access to justice, rules that are written prior to Gambia becoming a nation, a republic. So that's one of the mismatch between our independence and then the rules that are somehow very restrictive. And I think the judiciary somehow recognized that, because there is a lot of practice directive, and then even the Chief Justice bringing in some new rules to change some of those old practice rule to make so access to justice is deliverable. And then even with technology, which is also important. And then I have seen few courts where beneficiaries of that, but it's still, there's a lot of work that need to be done in the Gambian judiciary.
Absolutely, but Sadio, as someone who has been following the work of the judiciary very keenly, you believe that the Gambian judiciary in post-Jammeh Gambia is more independent than Jammeh's era judiciary, correct?
Yes, I think in fact they have absolute independence. That's my contention. I'm not saying a jurist, reasonable mind can disagree regarding judgment. But when I speak of independence, I think it's important to qualify this. There is no executive muscle or pressure on a judge to tell them this is how you must rule. Now, that is not to say that judges may not come far with their colleagues on the bench or behind the scene. I know that sometimes you share ideas, but no one is going to tell them how to rule on a particular matter. I sincerely believe that every jurist in Gambia has the ability to rule as they see the law from their viewpoint. Whether that interpretation is correct or wrong, that's for the higher courts to decide. But they don't have that pressure from the executive telling them how you must rule on certain issue. Now, are judges faced with issues that are contentious, that are a hot topic, just like here, and like cases like those veil issues? If you have to deal with abortion, immigration, any judge, you would understand the society pressure, but they still have that independence. It comes with the job, it comes with the territory, but they have that freedom and then the environment to interpret and then uphold the law as they are taught to do so.
Absolutely. Thank you very much. For those tuning in right now, this is the final take with me. Seni Marina in the studio is with, I will call him one of the country's brightest legal luminaries, even though he doesn't like titles. But that's Sergio Barrow for you. Sergio, one of your papers discuss constitutionalism and separation of power. What are the biggest gaps in the Gambia's 1997 constitution that continue to affect the balance of power between executive, legislature, and the judiciary?
I think the way the 97 Constitution was amended several times, especially the Second Republic, we have an executive who is hell-bent on consolidating power to make so his decisions or his act are not questioned. He's changed the Constitution so many times to a point even the way judges are removed from office, it is exposed to interpretation whether the president has the power under the current dispensation to remove a justice of the court. That's one. Two, when it comes to budgeting, a co-equal branch of the government, having your budget to go through the executive to determine whether that budget is sufficient, I think those are things we need to separate. That's also another issue in terms of resource allocation, and then how much resources are allocated to the executive. All these things spoke to the structural deficiencies the judiciary is facing because the true ideal of separation of powers is not recognized. And then the flaws start with the Constitution. I am very much okay the president appointing every other justice in the Gambia, from magistrate all the way to the last justice, with recommendation from the Judicial Service Commission. And then the Bar Association, people could put a vote of up and down on the justices and then be confirmed by a National Assembly. And then at that point, when they are confirmed, my contention or proposition is they should hold office for life, except for infirmity, impeachment by the parliament. That's how it should be, just like a president. And then that's what, if you want a true separation of powers, Supreme Court decided and then held that members of National Assembly could only be removed as dictated by the Constitution. The president doesn't have the power to remove a nominated member, even once that nomination gets confirmed. The same kind of protection should be required of justices, because the problem is Gambia is not, our jurisprudence is very young, it's not well tested. And then even in the United States, we have seen that lately, how provisions that we thought are well established jurisprudence have been tested lately, right? And then they have to go through court to see whether they would withstand the test of time. There's a lot of provisions in the Gambian constitution which are yet to be challenged in court. So we don't know where it will fall. So those are some of the issues where I think once the opportunity arises to do a new constitution, that separation of powers should be very intentional and then clearly established. And then that way each arm of the government is held to account by the order.
Okay. Sergio, when we talk about the 1997 Constitution, you were among people who also suggest very pertinent reform or provisions in the new Constitution when the CRC was given the mandate to draft a new Constitution that will stand the test of time for the people of the Gambia. And then the work was done. That might be a whole discussion. So, is Gambia still in need of a new constitution? That would replace this 1997 constitution, because the goal was to have that, and that was one of the campaign promises. But because of politics, we couldn't have a new constitution. Do we badly need a new constitution in order to have an effective change in December 2026 election? Because these are linked elections, and constitutions are like they are links. Will without a new constitution right now, will this have an implication on the December presidential elections?
No, I don't think absent of a constitution would have any implication on the election. The election can still proceed. It's first past the poll. Now, the inverse would be, is it possible to have a government? Right now, the government we have from 2021 is ruling by a mandate. When I say by a mandate, more than 50% threshold voted for the current government after the official results announced, right?
Yeah,
But there's
yeah.
always an opportunity that you could have a minority government ruling an entire country. That's the anomaly we are having in terms of the constitution we have. But there are also limitations on the constitution where for electoral laws, you cannot make certain changes if we are less than 6 months away from an election. I think for good reason too, because you don't want to make a power shift or imbalance between incumbent and the opposition. So for all purpose and intent, I think the Gambia will head to December with the constitution as is. But whether it's this current government that is retained or a new government coming in, I think their first order of business is an audit of all our laws. Gambia need to seriously sit and then audit our laws. There's a lot of issues, and then they don't come until when it's late. We always react to some of these laws rather than independently sit and then audit them. And then by audit, I want this to be open, notorious, and then that way citizens could be involved and then opine on them through their legislatures. That's very, very important. But we do need my preference would be a new constitution. And then if that's not there, they need to fundamentally overhaul the 97 constitution and then make those changes.
Yeah. But Sajo, the argument here is that the 1997 constitution has, a lot of advantages for the incumbent, and going by the 1997 constitution for elections will give some advantage to the incumbent, as we've seen with Yaya Jammeh winning, at least 4 elections in the Gambia with the 1997 constitution. So the fear of the opposition is that without a new constitution, there will be no level playing field for all political actors. Do you agree with this argument?
No, from a legal point of view, I think I wouldn't agree with that supposition or even argument. I think it has no, it's not tenable. That's my, if you're looking at the spirit of the law, with all its flaws, if you tell me an incumbent in Africa has an opportunity, yes. How do they have an opportunity? They are at the executive seat and then have state resources in terms of campaign. But the laws, the black letter laws are very clear. The black letter laws empowers opposition to have equal airtime at GRTS. It gives oppositions to campaign everywhere. And then it gives oppositions to raise finances how they want. There is no provision in the constitution that prohibit an opposition from raising money, just as the government. The mismatch is someone at the executive. There is this supposition that because they are the executive, they might commingle taxpayers' money with political party money, because the current government comes through a political party. So the contention or the better argument would be, how do we know the executive is not using our tax dollars in order to out-resource us in political campaign? But the problem is, and then this is where I push back on a lot of oppositions. It's very difficult for opposition parties to fund themselves. Most of them are funded by their constituents or sympathizers or supporters or well-wishers. But even at GRTS, they might do an entire program on the sitting government. I rarely watch it, but I've seen a lot of complaint that they don't feature opposition parties, they don't show their issues. So we know they are flouting the laws. But the question is, since 2017, Gambia's changed fundamentally. It's not the Gambia's judiciary. If everything all could agree on, every political party's leader, you bring them and then to your show, they would all agree that the judiciary is independent. Then why are they not challenging these provisions at court? Why are they not proactively? If I am a media house for opposition party, UDP, UMC, or whatever, and then we send our program to GRTS or we demand airtime and then they're not giving us airtime, Why are you not marching to court and then sue those people? That's where the issues are. Until then, we have a state institution flouting laws. There is someone there who is not respecting the laws, but you're not doing anything about it. And then if you don't do anything about it, how do we know the government somehow would not respect the rule of law? Until that happens, we wouldn't say we are in a constitutional crisis where the justices asked someone to do something and then they did not. Where we have a clear example of that is people who's, average citizen individuals, where state use excessive forces. We have seen courts made judgment against the government and then ask them to compensate those individuals. And then I have seen individuals write about that and then claiming that the state has not paid their money, or the government asks and the courts ask them to return certain aspect of their personal properties, and then it has not been done. If that happened, if I were their lawyer, I would return back to the court to require enforcement of that judgment. If the executive still refuse, then we know we are having a crisis. And then where we would see whether the National Assembly will step up and then do the right thing. But the problem with Gambia, as I said, in as much as we have a lack of reading culture, we also are very lackadaisical when it comes to forcing rights. You cannot be singing to me you want rule of law, and then I don't see you practicing it. We have seen a lot of executive orders come out here. People go to court and then say something. If they push back, lawyers go back to court. And then, whether those orders get enforced. That's what I wanted to see from our litigants. And then I'm not seeing that.
Yeah, that's something that is definitely lacking in the, and you have to hold everyone accountable for that, from lawmakers, lawyers, civil society organization. But Sadia, I have also seen civil society been somehow proactive. Like we have seen them taking certain cases to the Supreme Court. We have seen them taking the finance minister who delay the budget presentation in the parliament, outside the constitutional mandate. They also took, a lot of other cases, but I think there is still more room for improvement. Thank you for that. My next question will be about political accountability. How effectively is the current legal framework holding public officials accountable, especially in high-profile corruption and human rights cases? Do we have that legal framework holding those officials accountable?
Well, I think it depends where. When you say political accountability, IEC is the watchdog for political accountability in terms of whether they flout electoral laws or not. And then I would expect IEC being an independent agency. If I'm a political party and I see a party is flouting laws, IEC is not acting, I'm running to court to bring IEC over there to carry out their mandate. Now, within the government itself, I think the bigger, like this, we inherit from the First Republic, when we used to have a model through parliamentary system where most of the National Assembly members are the ministers for the government. We have the parliamentary system. We still have that kind of practice in the sense that even our constitution, our law says that bills could be brought to parliament by assembly members or even the executive. We still maintain some of that culture or practice from the parliamentary system we inherit from the British, but also the concept of Minister of Justice as well as Attorney General, those dual hats. So it makes it difficult. For me, my proposition is, in as much as Justice Attorney General has to be a cabinet official, that's still an independent law enforcement office. And then the Attorney General is and then should be considered from our constitutional framework as the chief law enforcement officer. What that means, the NIA and then the Gambia Police, they all have to be accountable to the Attorney General, not the other way around, if you want investigation to be done the way it should be. But we have this mismatch. In our constitution, it only defines Attorney General as an advisor to the cabinet,
President,
to the government, and then empower it for criminal investigation, but somehow subdelegate that to the DPP. But it doesn't give them the power for investigation. How can you prosecute if you cannot investigate? So even here, I'm not saying the police should not have IGP. They should, but they should be answerable to the Attorney General because they work for him. He's the one who should tax them for, like in as much as they are independent in their investigation. He could also, the Attorney General's office could start an investigation if they wanted to start it, to look into affairs, just how it is here, because it's a law enforcement office, and the Attorney General is the chief law enforcement officer in any country. But somehow, our chief law enforcement officers are the IGP and the Interior instead of the Attorney General. So they start investigation. So what end up happening always is like you kind of tie the hand of the Attorney Generals at their back, because they have to wait until the police investigate, bring them the case file. And I see it over and over where they would argue that, oh, we are waiting for
legal advice from the AG chambers.
So you send them whatever you send them, and then they advise whether that is sufficient or not, and they return it back. So that's not, it should be symbiotic. They should be working together and then building that case from day one. You don't need advice from them. They should be part of that investigation. That's how it should have started. But this mismatch is also making it difficult to even do high-level accountability. That's the problem.
So to ensure efficiency, how do we ensure that these institutions work together to ensure that there is justice and rule of law? Because most of the times, AG Chamber will say police bring them, incomplete investigations, and they won't be able to take those cases to court because the investigation is either incomplete or something is missing, and then sometimes there is case, but there is no evidence. We have seen the AG chambers losing a lot of high-profile cases, not because there is no case against those individuals, but there is no evidence that can convince the judges to convict. What do you think is leading to this issue that the Ministry of Justice is facing, or the police are facing, in trying to hold criminals accountable?
I think it is structural at its core. And then, as I say, it's not what you know, but it's what you can prove in court. Then to prove something, you have to have admissible evidence. Now, when I work here as a prosecutor, I know how closely we work with our law enforcement. From the word go, we build the cases together. So Gambia, that's where the problem is. If we address this in our legislation, or once we have an opportunity to restructure our constitution, it has to be recognized that the Attorney General office is the chief law enforcement officers, and then they can direct police to start investigation, open files, not the other way around. And then once those investigations are ongoing, the Attorney General has to have the ability to assign lawyers or embed them within the police. And then take Snoqualmie County in Everett, God forbid, if there is a high-profile murder that happened in the morning, you are not only showing, like the usual first responders will show up, but immediately the detective assigned to that area precinct,
the homicide,
because they're sending detectives to make sure, because you need to know how to collect that evidence. But if that's a major case like homicide, the assistant district attorney is on scene, who is prosecuting from the word go, talking to the detective, how the evidence are collected, because you want to make sure the evidentiary collection is done by the book. That way you can have admissible evidence in court. They are involved in that interrogation. They are quarterbacking and making sure whether the evidence is enough. Do we cross the line here? But it's Gambia where a case go all the way to trial, only to realize that a cautionary statement that was taken by a police, somehow there is no independent witness where the
or it's not taken in the right way.
So one of two things is correct. Either in police academy, we are not training or teaching police on such CISO, and then what we call the equivalent of 4th, 5th, and 6th Amendment in the US. Either that's not part of the police curriculum at the academy, or if it is part of it, there is no accountability mechanism to make sure to do that. And then if they are not trained by that, and then there is no one from the Ministry of Justice to coordinate, investigation would, in as much as they are men and women who want to do the right thing. But if you don't know whether you are collecting evidence the right way, it will be problematic. Now, police has a prosecution unit, and then I don't know how internally they work with evidence collection, but that's the whole problem. It used to be a capacity issue. 60 years ago, I support the idea police can prosecute lower crimes, just as it was in the UK. But now UK Crown Prosecutor's Office prosecute everything. Police don't prosecute anything because they have enough lawyers. So Gambia, what I expect, we have a lot of police officers should be educated. Police is an institution, just like military, right? For military court of justice, I can understand that. But for Gambia police, there should be no such thing as a police prosecutor in Gambia anymore. Not in 2026. We can have police that are trained in the law, just like how you have a lot of lawyers that are FBI agent, because that would help them the background to know how to collect.
So, Sadio, why don't you think the police cannot prosecute cases in court? Because they have the mandate to prosecute, right?
They do, but I know the reason. The problem is how we get there. I'm not saying they don't have the capacity to prosecute. I'm just saying they should not be prosecuted. That should end by now. Just like how when the Drug Enforcement Act came in, allowed drug enforcement to prosecute. If I
their own cases, yes, and separated from the police role, because you remember before the police used to be in charge of drug cases, like the police are the drug squad, but now the drug law enforcement is its own entity, and they have their own prosecutorial powers to prosecute drug offenses in court.
That should not even happen. I know it has not been challenged, but the whole concept of you cannot be the judge, jury, and executioner, there's a strong argument. What agency will spend their resources, investigate a crime, and somehow decided that objectively looking at this evidence, we are not going to prosecute, even if they blundered? They're not going to do that. So there's a strong contention that that's collusion. That prosecution could challenge. No one ever challenged it. I mean, the problem is we inherited, before it was a human resource problem. We may not have enough lawyers within the Ministry of Justice to prosecute these cases, but that's no longer the case. My contention is police are highly trained. They could be well educated, and then we can have them within different field where they are learned in the law. But if they want to be prosecutors, let them take a secondment or whatever you call it. Let them go and work as prosecutors. Police should be responsible for investigating. That way, you have that separation, and then the Ministry of Justice will have that oversight, and then could review their evidence and say, no, this is not enough. Oh, no, this is problematic. And then they could even hold them to account when there is some kind of constitutional violation. What police officer would prosecute another police for violating some of the constitutional tenet of a suspect? They might not even be inclined to do that. As the saying goes here, the blue wall silence, and we've seen those things. It comes to public integrity appearance. So Gambia, I don't know who drafted that statute, but the idea that either police or even drug enforcement, the people that are responsible for arresting you, for prosecuting you, that has to change. I don't know how we still have those statutes on the book, but that has to change. From everywhere, from Basse to Koina to all the way to Katong, we should have a state attorney's office everywhere addressing these issues and then taking prosecution in our cases, and then the police would still be a law enforcement unit. That's what their role is.
Is that a modern policing, or it's just a standard?
No, I think that's what policing is all about. If you go all the way back to Peel policing, I'm a criminal justice major on my undergraduate. From Peel policing, the early concept of police when it came about. The problem is even in the UK, I think, as I mentioned earlier, I think it's happen chance, resource issues, and human capital issues. 60 years ago, we may not have enough lawyers or even the motivations to have lawyers to go, let's say, work in CRR, in Yaminas, or in the Basse to address these issues. So what happened is we allow police constable who, at least by virtue of their work, they might be exposed to courts, and then they can address some of these issues and then have right of audience at the magistrate courts. So I know even in Gambia right now, police usually have right of audience, I think, in magistrate court. But when it comes to high court, the Ministry of Justice will appear. But it used to be a capacity issue. But now my contention is university has graduated so many young professionals. We don't need to engage in that practice. The people that we inherit from the UK, they themselves have changed their position on that, and then now have crown prosecutors prosecuting the cases that are going to court. So the Gambia should follow suit, and then our police should continue to be well educated. They should receive training, resources. They can even be learned in the law. If anything, that would only enhance their capacity in terms of investigation, evidence collection, human rights practices. So I am all up for that. But I think the idea of prosecuting cases themselves, we must divest that from the police as well as any law enforcement agent like the drug enforcement squad, and then return that mandate back to the Justice Ministry.
Hello, Sajo. Can you hear me?
Yes, I can hear you. Yes, I can hear you.
Hello, Sajo. Can you hear me?
Yes, I can hear you.
Oh, you can hear me. Okay. Somebody sent me a call, so I think that kind of play with my stuff. But can you hear me, right?
Yes, I can hear you loud and clear.
Yeah, but I can hear you. It seems you are on mute.
No, I'm not muted. I can hear you loud and clear.
I can hear you.
Maybe it has to do with your sound system. You may have to go in and out, but I can hear you loud and clear.
I can hear you.
You may want to log off and then log back on again.
It's so interesting, but unfortunately with this call coming in, oh, you can hear me loud and clear. I can hear you though.
Yeah, you may want to log off and log back in. If you have calls, usually it does that.
It's a very interesting conversation. Okay. I am here, but I don't know why you can hear me. Let me see.
I can hear you still. I can hear you loud and clear.
Tune into the final take with MK Mariner every Saturday on the Alcamba Times and experience extensive conversations on a variety of topics, including national and international headlines, breaking issues, and major developments in politics, business, innovation, science, and sports, along with inspiring stories and expert analysis to provide a comprehensive understanding of the news.
Okay, Sajo, can you hear me now?
Tune into the final take with MK Mariner every Saturday on the Alcamba Times and experience extensive conversations on a variety of topics, including national and...
Okay. Sorry about that. You know, you told me about it. Somebody just called me while I was on live because I'm using my phone today. But you can hear me, right? Can you speak so I can hear you?
Yes, I can hear you loud and clear.
Okay.
It's just put it do not disturb, and then if they call you, it kick you out. I used to have that experience.
Oh my God, guys, please stop calling me. I am using my phone to record today. So hopefully next week I will get a new laptop so that, you know, you guys will not be able to disturb me. But Sajo, that was a very, very interesting, brilliant expose from you. I'm learning a lot, and I'm so my audience are also learning from that. But I can hear you at the later part of it, so you might reverse a little bit so we can move from there, because we are left with at least 10 more minutes because it's a 1 hour program, and I have a lot of questions for you. But you know, legal conversations are always expanding, especially when it comes to Gambia legal system, which is very, very complex, I will say. But anyway, thank you for that. So I will move to my next question. Let's talk about recent developments in the Gambia. Sayo, the Gambia is advancing a new immigration law. You have warned that the new immigration law might, not be human right friendly after reviewing what you have seen. Can you tell us your fear about the new immigration law and how best we can make it a best standard immigration law for the Gambia? Because Gambia has not had an immigration law for more than 50 years. And here we are, because recently we have seen a lot of young people been taken advantage by human smugglers using the dangerous way to Europe, and most of the time our young people are dying at the high sea. They are dying in the desert. And the government say, hey, look, you cannot take human life like that. And there is a law now that you can spend many, many years in jail just because you risk somebody's life through this bad way. What are your concerns about this new immigration law?
Well, the last time we had an immigration act was 65. There were a few amendments.
Wow.
That was the one in question. So this is an opportunity for all of us in our lifetime to actually see how immigration is addressed. Regarding exploitation of young people, even other criminal statutes could address that. Trafficking statutes, human smuggling, we can have that in our regular criminal law business, and then that should suffice. My concern is immigration is national security, and then they're entwined. I work in that area extensively for almost a decade from all sides of the aisle, and then that's why I was a little bit concerned. But frankly, more importantly, we have a 97 constitution. You cannot just draft a bill and then not run it by the constitution. But under the current bill, the issue I have, in as much as I am for all, if you have serious individuals where we think they are a danger to public safety issues, or flight risks in immigration, detention is appropriate. But you cannot have a provision that give unlimited power to detain people forever without offending the Constitution. When the Constitution, it doesn't say Gambian citizen, it says any person. By the 97 Constitution itself, you cannot detain anyone for 372 hours without bringing them to court and then address detention. And here you are with immigration statute and then giving the minister the power to detain somebody indefinitely. Of course, that's going to be a problem. So these are some of the issues I want our lawmakers to look into and then address it. But the fundamental problem is, and then I used to think the executive is where our focus should be. I'm not saying that's not important. Leadership matters even within the executive structure. But lately, even watching the immigration bill debate, what I have come to realize and then learn, our National Assembly is more critical than the executive. I'm not even worried about executive anymore. I am more concerned about the people we send to represent us and write laws for us. And then I think my argument is going forward, in as much as everyone should be political, they should not be partisan when it comes to National Assembly. Gone are the days to have people representing you who would not grasp the task they are asked to do. And then respectfully, watching that debate, I was concerned where people don't understand the laws that are in front of them. And then the fundamental issue is your primary function as a lawmaker is to write laws. But not only can you not do that, when you ask us to empower you and become an institution, remember in 2018, National Assembly became an institution. And then they have the National Assembly Service Act. They have in-house councils, people that could help them. Yet most of the laws are coming from the executive. You are not writing those laws. You're only reviewing them. You don't understand the author that wrote that law, the choice of word, why they use certain adjectives. You don't understand it. And then you're struggling with that. And then you just come and then change a couple of things and pass it without understanding the repercussion. Because you don't even run that law by the Constitution, whether it's even suffice. So that was an eye-opener for me. And then with the immigration bill, I saw even the sections or some of the terms they are using. There's a mismatch in the terms. And then it creates problem. I know that because US went through the same issues. There are times they were using terms like entry, which is a legal act, a term of art. And then my argument is you leave those things open, we may end up having someone, a criminal alien, who may happen to do something serious and you cannot do much about it. And then it also speaks about other laws like the Refugee Act we have in 2008, But for an immigration officer standing at Kara, doesn't have any mechanism how to breach the Refugee Act right, which says people could submit application to the Refugee Commission, which is set up. But it did not tell you any mechanism what you do to someone who just arrived at our border in Kara. They have no passport, no documentation that allow them for entry, but they claim that they have a fear of return to their home country. There's no process. So what does that officer do? So these are some of the things they are not thinking of, because you have to be ahead of these things to know if someone arrived at our land border and then claiming a fear of return, what can that immigration officer do to break the gap between the Refugee Act and the Immigration Act? Or someone who arrived at our border, they have no documentation, no paperwork, just like the backdoor syndrome, like the backway syndrome we are seeing here. And then they are not claiming any fear of return. What power does the immigration officer have to return that person? Because clearly they have no documentation to enter the country. We should have those processes where the officers have the ability to do expedited removal and then return that person without wasting our resources. So this is the 21st century, it's 2026. And then these are some of the issues I want our lawmakers to be thinking about, because immigration is very much intertwined with national security. And then that's something we cannot afford to get it wrong. We should be welcoming, but at the same time, the laws must be very intentional in the way it can protect everybody.
So, Sergio, you think that our National Assembly should thoroughly scrutinize this immigration bill to ensure that it do not harm people they want to protect, right?
That's one of the issues, but most importantly, to protect the people that are in the country. So I've written about that, and then I put a position paper, and then I'm hopeful that some of them would take a closer look at that, and then see some of the things they can do to change that, to at least adjust the bill to be more secure, more just, while at the same time honoring our obligations in all these treaties they are signing, because it's the same assembly that is signing the country to all these treaties and ratifying them. If you are ratifying document, you better make sure our domestic legislation comply with those.
And do you know that Gambia is also a signatory to international protocols on migration and immigration? How do they navigate between these local laws and also international treaties that they have signed up to? Should these national laws come in conflict with international treaties? What should be done?
Well, that's why
because they domesticate most of these international treaties on migration, in Africa, statelessness.
That's true. That's why if you sign up for some of these laws and then you ratify them, it's important to make sure your domestic, especially if you have not taken any reservation to those laws. Because US, we signed the Refugee Convention, the 61 Protocol, all of those things.
Yeah.
We have a regulation, precisely, I think, HCFR 1208.17 and 18 regarding Convention Against Torture. We implement them through regulation, and then we saw our reservation where it ends. So most of these treaties, it says a foundation as to who is a refugee, recognize those definition, and then when we sign our domestic legislations should tell and then indicate, for instance, a refugee is someone who is outside the US, and then they are coming through resettlement. An asylum applicant is someone who is within the physical borders of the US. You could apply for that. So Gambia, so we want to make sure when we incorporate this concept, so if you are outside our border, are you eligible for asylum, or must you be within the physical borders of the US, Gambia to claim that? And then if you arrived at the post in Karam, and then you claim a fear of return, and then would the law consider you as arrived in the Gambia or not yet arrived? That was the question the US Supreme Court has just decided a few days ago. These are the questions we need to be thinking about in how we address this issue in terms of giving them forum and the right. Those things are important. And then if you are someone who committed serious crimes, like you get a serious non-political crime conviction in your home country, should our laws be tailored in such a way where asylum, we should consider it as a discretionary form of relief, where we will say that, look, you are not going to get the benefit of asylum in order to get residency in Gambia because you have committed a grave, serious non-political crime. Or if someone is granted refugee status in Gambia and then they have interaction with our criminal justice system, they get a conviction for felony, Are we going to take that benefit from them? Those are the questions the bill should address. Or other than our commitment to non-refoulement, when we know returning to your country would result in torture, we're not going to
Yeah.
send you. And then our constitution blanket ban on torture. Are we going to give you some kind of relief or benefit from the state in terms of welfare and social welfare if you are someone who committed serious crime in our own country? Should we take your refugee status, but we are not going to return to a country where there will be no refoulement? And then also, do we have the ability to send you to a third country if they are willing to provide you? Like you said, these are the things we should be thinking ahead of time, and I don't see that there. So these are all consideration. Our National Assembly, I want them to be thinking about this issue. I don't want them to be thinking about the moment. Think 10, 15 years from now, how does this impact the country where the borders are fixed, the population is growing, and then what do we do to make us safe and then welcome people at the same time? That's what they should be thinking about.
Absolutely. So, Sayo, this bring me back to the question. During Jammeh's time, a lot of Gambians, including myself, speaking to you, had to go to Senegal to look for protection, to after, I feel that my life is, is not safe back home in the Gambia. And Senegal provide that protection. I registered with the Senegalese Refugee Commission, and they gave me a card, and they protect me under ECOWAS Convention or Protocol on Refugee and Statelessness. I think, Gambia has also been a sanctuary for some political opponents in other parts of Africa. Right now, the Cameroonian opposition leader is currently, been provided protection, asylum protection in the Gambia, because he feel that after the election in Cameroon, the Paul Biya administration was after him. So he ran and came into Gambia, where he seek political asylum. And as we speak, he is currently there. I think Gambia could have done better to align its new immigration law with international best practice, like the ECOWAS standard, the regional standard. As a legal luminary, or a legal with experience in immigration, what do you think Gambia could have done better to safeguard itself from, to look at the security implication of the immigration, and also as well as safeguard the human right of those they are trying to protect?
I think it comes down to a balance. You can have an immigration bill that provides us security, but still welcoming. At the end of the day, it's all about process. And then this require lawmakers to be very much intentional and then looked at the cost implication. Maybe Gambia, in as much as National Assembly is an institution, when they bring in bills, like here, you have the Congressional Budget Office and the likes, they will study bills and then see how much physical impact that will bring on the government, how much job it will produce, and then we actually know whether this bill is good or bad for the country, right? So that's the kind of assessment I want our lawmakers. They don't have to know that, but like they are an institution, they have experts, they could actually study the bill. What would be the cost of this bill in 5-10 years? What other benefits would it bring? And then if we are going to do a refugee status, are we going to put a nominal fee or a zero fee for anyone who is there? But my whole point is there has to be a process. That's what I'm asking for. Let there be a process. Let there be no mismatch. We have a bunch of laws, and then it does not address what the process is or what the process are clearly defined. The law should be clear enough to let someone know if you arrived at Karang, you are running away from harm in Senegal, just as Senegal extended courtesy to Gambians during the Second Republic. What must you do? Most Gambians were fortunate enough because they have that ECOWAS pass, they could just enter Senegal without actually declaring at the border that they are going to be a refugee. Once they arrive within the four corners of Senegal, inside, they would go and then register. You can do the same thing in Gambia. If you're within the physical borders of Gambia, you could go to the Refugee Commission. I don't know whether one is set up, but there is a law that says we should have a Refugee Commission that address these issues, right? So you can do that. But let's say if our borders are secure or we are sophisticated in such a way, someone arrived and they don't have their Senegalese document with them to enter the ECOWAS pass, they don't have laissez-passer, and then they claim that, look, I'm running away, I left this document, and I'm seeking refugee status. So what now? The law doesn't say. But now,
and these are very special circumstances in refugees' case, especially people fleeing political prosecution. of violence or whatever you might call it, sometimes they forget their documents. They don't even carry them. So you are saying that the new law is very vague on that aspect, right?
Because it doesn't break the Immigration Act. They see it as giving papers to people, but it doesn't actually address how someone who wanted to access our refugee statute is outside the
Yes.
country or at the border. How do they break that? Because the individual at that karang is the immigration officer standing
Officer,
post.
yeah. Mhm.
The law give a mandate that the immigration officer should have a process for asylum, but it doesn't tell the officer how. If it is the classic case of the US, what the regulation and the law tells you, if someone came and then claimed that they have a fear of return, you have to do initial screening. You take a sworn statement, ask them a fear, if they have a fear of return, and then you must within 7 days or 14 days refer them for what we call a credible fear hearing to see whether they could make a positive credible fear regarding the. It's
Mhm.
not detailed or extensive, just to see, given what all that they said, if you take their statement to be true, is there a plausible ground that they would meet the asylee or refugee status? If the answer is yes, you continue to process them. If the answer is no, they could be subjected to expedited return, and then you remove them back.
Hmm.
And then also the Montreal Convention and these the conventions we sign and the Convention on Consular Practices. If someone arrived at our border, Gambia is a signatory. You have a obligation to ask them whether you want them to contact their embassy or whether they would decline. These are all training that our officers should know, and then the law should clearly spell out for the officers at the border. That way, it will be part of their training manual and then operating standard. If people arrive at the border, they know how to screen someone who doesn't have any paperwork. Now, it may not be a problem if someone come with a Senegalese passport and then or Senegalese document, because we have ECOWAS free movement of people telling you I'm just going to Gambia for a day or two. While they are within the country, they could address that. But you want to also contemplate if someone is at the border without those documentation, and then the powers the officers have to return someone, or if even if they come with a paperwork. I want, like, our immigration law should be written like, for instance, a visa is a file. It only gives you right to enter a flight to come to the US. It doesn't
Mhm.
guarantee you entry. The officer would inspect and admit.
Yeah,
They
yeah.
can refuse that and they revoke it. That's Those are some of the things I flag to review it. So if our officers have the power to admit people, do they have the power to revoke anyone who has a document? Could they deny entry? What are the bases? And then why not we define what admission is? Is it procedural regularity or substantive regularity? These are the things you have to be thinking about, because the law is quite nuanced, and then you don't want people to get caught up with these issues. And then sometimes the act would use entry. Well, I can enter a country, but I may not be admitted. That was the argument used. You come here illegally, maybe you jump the fence, you don't have contact with immigration. We call it entry without inspection. You're in the country, you have entered. So now what? So they wised up, and then they realized that in '96 they changed their statute. They're like, you know
Mhm.
what? No more entry without inspection. You are either admitted or an applicant for admission. If you escape or somehow you made it into the country, you might be physically within the country, but legally you've never been admitted. You're still an applicant for admission. If we caught you, we know how the law applies. So these are the things I want our lawmakers to be thinking out, because these words have meaning and it's important to understand. So you're using entry at one point, saying admission at one point. There's this mismatch, and I don't want them to
That's
box
a
it
confusion,
in
yeah. Mm.
difficult for
Absolutely.
the sitting government to address those crises when it happens.
Mm. Sergio, this is a very interesting topic, but we are almost at the tail end of this interview. It's 1 hour 8 minutes as we speak right now, and I know you want to watch football. I see you love football too, but just give me 5 more minutes, and then we should be able to be finished with this interview. But I'll be having you regularly to have this very important conversation. Sergio, we're still on immigration. A high profile case is unfolding. A German national has been arrested in Gambia right now. And then the immigrations rush to the High Court for granting him personal no grantor, meaning he has to leave. So the lawyers for this suspect, I will call, one Mohammed Reni, he has different names, and that's up to the court interpretation. But the name that we know is Mohammed Reni. So they didn't specify what kind of crime he committed, but they said he's a threat to national security and he must leave the country. He must leave the country. So his counsel took the matter to the High Court, and the High Court provide a short relief that, they cannot deport him to a third country, that's German, without full hearing. The case returned to court next week, Monday. What is your take on this? Do you think that the immigration acted within their powers to grant this man Mohammed Reni personal no grantor, or the court acted in the right way to deny
Now,
deported?
I'm not going to. I would give some deference and respect to the court, and then I'm not going to opine on how I think the outcome would be. But this is what I'm going to speak about: what the law is, and then those things are important.
Yeah.
The law, current laws as stand, 1965 law. The minister has the power, even if you're a resident, the equivalent of a green card holder in Gambia, to cancel that for any or no reason at all. That's the law as written. That's why this new immigration bill is very important for citizens to review it. So the government can look at anyone. Is what we call.
So the minister has that power, right?
Has the power to revoke the status of any non-Gambian for any reason or no reason at all. And then that decision is not subjected to judicial review. Now, we will address that, whether that could confine with the 97 Constitution, but the government has that power. That has to be very clear. And then two, in fact, the statute, the language the statute used is undesirable. It's the diplomatic cousin of personal non grantor. The minister has the power, unfettered power, absolutely, to look at any non-citizen and then find them to be desirable in the Gambia and then provide no reason, and then that would be lawful according to the new Immigration Act. He can detain you for indefinite time.
But Sayo, don't you think that's an abuse, of power with no reason? They can come and say, hey, Semi, we are deporting you to the US, without no reason.
Now we are talking about, that's why I said we need to audit our laws. This law was written in 1965. And then it preceded almost 30 years before the Constitution. No one ever audit the law, whether it will conflict with the Constitution as written right now. And then I have, in fact, written on that. That's why I said, from an operational point of view, the black law letter, the minister has that power. Whether that power conflict with the Constitution, no one has tested that yet. But I'm telling you, the government has the power to find any non-citizen. The timing could be suspicious. The timing could be seen to
be because he's accused of involved in political financing,
Exactly. But my point is the government did not act outside the law in doing what they did. You might find the conduct to be repugnant, morally repugnant, but it's not unlawful.
So their action as per law is justifiable and is illegal, right?
Even if they are moving on corrupt intent. That's my point. It could be like, I want to take my competitor out. Someone is financing my competitor. Let's say even that's the case. I'm not arguing that.
Yeah, I know.
That could be a motivation to remove the person and then send them. No court can review that. Two, it is our very Supreme Court that have stated that no injunction can lie against the state.
In court?
In court. That's black letter law from 2001 UDP versus IEC, all the way to Yakumba case, to the Auditor General case. That's black letter law. Now, even if you rush for a temporary emergency order, what we call temporary restraining order. Now, I can understand. That's why I don't want to go into that. But my point is the law as written, no injunction can lie against the state. What does that mean? The guy will be deported. Any individual who the government want to remove, they can remove them. It doesn't mean the litigation would not continue. What became of that litigation might continue later, but the government has the power to do so.
But Sayo, let's this be clear. Can the government remove you under the Immigration Act without going through a judge?
Yes, that's what the act
But in this case, the state itself took the matter to the court.
I don't know why they did. And they took the matter to the court. I'm saying they can do that. But I'm saying the minister has the power. It doesn't have to go to the court. Could actually declare anyone undesirable, which basically is personal non-grantor, and then have that person removed. If that person wants, the person can go. That individual you want to exercise that power against can rush to the court and claim that, look, I'm not saying the minister doesn't have this power. My argument is this minister's power contravene against the Constitution. At bare minimum, I have the right to be given the opportunity and the right to respond. That's the basic natural justice principle, and it has been in common law since 1600 in Bach's case. So that's a very legitimate cause. My argument is no one ever tested the immigration provision since 97 Constitution came. So the law as written, that's there. But there's also our Supreme Court's jurisprudence is no injunction could lie against the state. That is not to say that the act of the minister may not be unlawful to remove somebody, but the government has the power to remove that person off the country while the case goes.
So this brings me back to still the immigration law. So Sadio, if you want to take me out from Gambia and you are sending me to a third party where my safety is going to be a concern, and internationally human rights law say you cannot send somebody to a country where he's gonna face persecution, or his life, his safety and security will be jeopardized.
That is true. And then our Refugee Act is called non-refoulement. You shouldn't send someone to a country where they will be tortured. Now, that is different from someone. Let's say if I commit a crime from country A and I run to country B and then they want to return me back there. And then my argument is, oh, I don't want to be prosecuted. Prosecution is not the same thing as persecution. Those things are different. So the law is in the Gambia. That's why I said I don't want to get into the nuance of this. The government has the power to remove you. If you believe the country the government wanted to send you, you believe you will be persecuted as defined in the Refugee Act, you could actually go to High Court and tell the court that, hey, the Gambia is a signatory to this convention. The Gambia 2008 Refugee Act proscribed against refoulement, and then they want to return me to country B. If I go there, they will torture me. So there might be a hearing to see whether you could meet that evidentiary burden to show that whether returning to that country would constitute refoulement. And if the court found so, they might protect you and then stop that. But here is where the problem rises. And then that's how it's supposed to go. But our jurisprudence as is right now says that you cannot get an injunctive relief against the state. So what does that mean? They could send you to that country where possibly you could be tortured while this
executed.
While this hearing is going on. So that's the mismatch between the law and the act, and no one has challenged that. That's what I'm trying to put across.
So anyway, it's very interesting. Sergio, people are not testing the waters in the Gambia because all these laws, no one is challenging them in the courts, and it's sad that people are not taking or challenging some of these laws, because laws might be good, but we need reforms also. Like you say, our laws need audit. And when you talk about audit, people in the Gambia think it's only financial audit. No, it's also law audit, where you look at these laws. Just look at the case of death penalty. There was a moratorium on the death penalty in the Gambia. And the National Assembly, by law, I think every 10 years, I'm not a lawyer, you might correct me, they need to review the death penalty, although it has been abolished in the Gambia, but they have been called recently because of the rise in crimes. Even MPs are proposing that the Gambia should introduce the death penalty to serve as a deterrent for these serious crimes like rape, murder, robbery, because we have seen a lot of those ones happening in the country. So what do you think should be done in the next 5 years in terms of reviewing our laws? What are the major things you think need to be reformed, in our law books, going forward?
Well, at least there is some effort. We have the new Criminal Justice Act, which is the Criminal Procedure Code, and then the Criminal Law Act itself. And then there was talk about the new Evidence Act. From the old one was 94, the one I was familiar with, and then they've been changing that. But we have law reform or law report in Gambia. I think that's entirely within their providence to look at the law. But most importantly, National Assembly, that's their job. If you're a National Assembly member, I mean, I am okay with the privileges that come with that office require them to also do some work. Look into the law statute. Most importantly, their website, fix it. Gambia National Assembly website should have every law that National Assembly has passed. Every bill under consideration should be on the website for citizens to review and then opine on it. We don't have that. it's so difficult to even know what are some of the laws
What's
there.
good?
Yeah.
Yeah.
So they should pass a law to make so all our jurisprudence, our court decisions are on the website. If you go to the
Yeah,
judiciary,
digital, yeah.
any state here, you find all those things there. You could
Yeah.
look at everything under consideration, how the bills are moving. So all these per diems they are giving themselves, fighting over for ECOWAS and others, put that money somewhere where it will benefit the citizens. That's my
But
idea.
I think there is a law reform committee at the judiciary or Ministry of Justice. That role is to make sure that the laws are reviewed, and they are reformed, and they are also into this into digital setup. But anyway, Sergio, finally, I know I have taken a lot of your time. Finally, if you could recommend one concrete action to Gambia government and one to the Gambian people to improve the legal and justice system, what would they be? Final question.
Let us not be afraid of change. Sometimes change can be good. I think our biggest fear is change. People are afraid to change or adapt a new system. And then read. The only recommendation I will let them read any critics of the government or the assembly, review it, and then see whether it has merit. And then that's what I hope to achieve in my writing. I just hope somebody would take the time to read, and then you can agree or disagree, but at least it's an opportunity for all of us to learn and grow.
Yeah, absolutely. For those who watching, this is the final take, and this brings us to the end of this marathon interview. I will say it's 1 hour 21 minutes with me, Sergio Barrow, a Gambian legal scholar based here in the US. Sergio has written extensively about Gambia's legal system, and he's also a former immigration attorney. He knows a lot about immigration work, both in the Gambia and the US, but with more focus on the US. So, Sergio, many thanks. I will allow you to go and watch the last part of Morocco-Canada game. I know you are a foot soccer fan. And once again, happy independence to you and your family out there in Indiana. So we will keep this conversation going. And then I must thank you once again for your time, because it's hard to have you on source.
Yes.
People just see your writings. They hardly see your face except your photo, that accompany most of your writing. But it's good that you are here with us today. Many thanks for joining the final take today.
Thank you, Seni. I appreciate the time and the opportunity. Have a good rest of the day.
You too. Thank you. Bye.
Tune into the final take with MK Mariner every Saturday on the Alcamba Times and experience extensive conversations on a variety of topics, including national and international headlines, breaking issues, and major developments in politics, business, innovation, science, and sports, along with inspiring stories and expert analysis to provide a comprehensive understanding of the news.